The 71st session of the Senate, in the first regular session of the 16th Congress, is hereby called to order. The chamber will be led in prayer by Senator Sonny Angara.
Mapagmahal na Panginoon, tinatanggap namin at walang hanggan ang aming pagpapasalamat sa iyo. Sa araw na ito ng iyong pagkalinga sa amin ng mga mamamayan nitong bansang marangal na sa tuwin ay iyong pinagpapala. O makapangyarihang Panginoon, naway iyong pairalin sa bulwagang ito ngayong araw ang mga gawa, salita at katwiran na ang pinakasandigan ay ang aming pagdakila sa iyong pangalan. Sapagkat ninanais ng aming puso at diwa na paglingkuran ang aming bayan at kapwa, kasabay ng aming pagkilala sa iyong kabanalan at kaluwalhatian. Ito ang aming idinadalangin sa iyo na Panginoon ng langit at lupa. Amen.
Thank you, Senator Angara. The Secretary will call the roll.
The Honorable Senators Angara, Aquino, Binay, Cayetano Alan Peter Compañero S., Cayetano Pia S., Defensor Santiago, Ejercito, Enrile, Escudero, Estrada, Gingona, Honasan, Lapid, Legarda, Marcos, Usmeña, Pimentel, Po, Recto, Revilla, Soto, Trillanes, Villar. Senate President Trilon.
21 senators are present. The chair declares the presence of a quorum. Majority Leader.
Good afternoon, Mr. President, to our dear colleagues. Mr. President, I move that we dispense with the reading of the journal of the 70th session, May 13, 2014, and consider the same as approved.
Any objection? Hearing none. The reading of the journal of session number 70, Tuesday, May 13, 2014, is hereby dispensed with, and the same is hereby approved.
Mr. President, may we welcome to the Senate officers and members of the Soroptimist International of the Philippines, Region A Foundation, Incorporated, headed by former Mayor Lorna Silverio, Chairperson Unsung Women Heroes Award. May I ask them to stand to be recognized. Ms. Maria Rosario Tumaneng, Governor-elect of the Soroptimist. Ms. Carmen Flor, past Governor, Soroptimist International, 2014 Unsung Women Heroes Awardees, and the 2009 to 2013 Unsung Women Heroes Awardees. These are guests of Senator Legarda, Mr. President.
We welcome the Soroptimist International of the Philippines to the Senate, and let the presence of the officers and members be made of record, led by former Mayor Lorna Silverio, President Ms. Maria Rosario Tumaneng, Ms. Carmen Flor, the Unsung Heroes of 2014 awardees, together with the awardees of 2013 Unsung Heroes. Welcome to the Senate, ladies of the Soroptimist.
Mr. President, we also have REACT Philippines, the Regional Emergency Assistance Communication Team. This is the organization that helps the government nationwide in times of calamity and disaster. The National President, Barangay Captain Filimon Tutica Jr., past National President Mr. Richard Ricky Valdez, incoming National President Mr. Greg Pacifico, and Chief of Staff Mr. Jofelyn Concepcion are here with us. May I ask them to rise to be recognized also?
We make of record and welcome to the Senate the presence of the Regional Emergency Assistance Communication Team, or REACT, led by its National President, Barangay Captain Filimon Tutica Jr., past National President Mr. Valdez, incoming National President Mr. Pacifico, and the Chief of Staff Mr. Concepcion. Thank you.
Mr. President, it is also always a pleasure when the leaders of our local government from all over the country visit us. Today we have Mayor Peter Alos from Atok Benguet, Vice Mayor Simon Modawan Lakwasan from Bauco Mountain Province, and Councilor Labor Moises Masidong, Bauco Mountain Province, and their companions. May we also recognize them and welcome them to the Senate, Mr. President.
The presence of Mayor Peter Alos of Atok Benguet, Vice Mayor Simon Lukwasan of Bauco Mountain Province, the councilors are hereby welcome to the Senate, and their presence made of record. Welcome.
Mr. President, we also have esteemed Dean of the FEU Institute of Law and my professor in the Ateneo College of Law, TV5 broadcaster and legal analyst, Dean Mel Santamaria, who is here with us today.
Dean Mel Santamaria, the Dean of the FEU Institute of Law and a professor in that university, Ateneo College of Law, TV broadcaster and legal analyst, Dean Mel Santamaria. You're welcome to the Senate.
Thank you, Mr. President. And lastly but not the least, Mr. President, the Obrero Youth Organization from Tondo, Manila. Their officers are here today, led by Pogs Reyes, their president. May I ask them to stand up to be recognized?
The Obrero Youth Organization of Tondo, Manila, led by its president, Mr. Pogs Reyes, is welcome to the Senate.
Mr. President, I move that we proceed with the reference of business.
The Secretary will read the reference of business.
Messages of the President of the Philippines. Letters of His Excellency President Benigno S. Aquino III, dated 5 May 2014, submitting for the Senate's consideration and concurrence the following. Agreement on Social Security between the Republic of the Philippines and the Kingdom of Denmark, which was signed on 11 September 2012 in Copenhagen, Denmark. Nagoya Protocol on Access to Genetic Resources and the fair and equitable sharing of benefits arising from their utilization to the Convention on Biological Diversity, which was signed on 29 October 2010 in Nagoya, Japan, and Protocol relating to an amendment to the Convention on International Civil Aviation, Article 3 bis, which was signed on 10 May 1984 in Montreal, Canada.
Committee on Foreign Relations.
Bills on first reading. Senate number 2220, entitled An Act Providing for a Magna Carta for the Road Transportation Sector by Senator Recto.
Public Services, Public Works, Ways and Means.
Senate number 2221, an act declaring July 27 of every year a special non-working holiday in observance of the founding anniversary of the Iglesia ni Cristo by Senator Ligarda.
Education, Arts and Culture.
Senate number 2222, an act providing for a Magna Carta for workers in the energy sector of the Philippines, authorizing the collection and appropriation of funds therefore and for other purposes by Senator Ligarda.
Energy, Civil Service, Government Organization, Finance.
Senate number 2223, an act exempting marginal income earners from income tax and value-added tax, amending for the purpose sections 22, 24, 109, subsection 1 and 236 of the National Internal Revenue Code of 1997 as amended, and for other purposes by Senator Recto.
Ways and Means.
Senate number 2224, an act declaring July 27 of every year as a special national non-working holiday in commemoration of the founding anniversary of the Iglesia ni Cristo in the Philippines by Senator Recto.
Education, Arts and Culture.
Resolutions, PS Resolution number 645, directing the appropriate Senate committee to conduct an inquiry in aid of legislation on the El Nino-Southern Oscillation phenomenon and determine the appropriate Philippine government intervention with intent of strengthening the mandates of government agencies and ensuring the adequate, safe, and affordable water supply. Senator Recto.
Climate Change, Agriculture and Food.
PS Resolution number 646, urging the proper Senate committee to review the implementation of Republic Act number 9004 or the Ecological Solid Waste Management Act of 2000 and other pertinent laws and local ordinances with the objective of increasing penalties against offenders to further protect the declining state of the environment and ultimately avert a garbage crisis by Senator Grace Poe.
Environment and Natural Resources and Local Governments.
Yes, Resolution number 647, urging the Senate Committee on Public Order and Dangerous Drugs to conduct an inquiry in aid of legislation on the continuously increasing criminality and the brazenness of criminal illegal activities, with objectives of crafting short and long-term plans and policies regarding crime prevention and eradication by Senator Grace Poe.
Public Order and Dangerous Drugs. Majority Leader.
Mr. President, may I ask for a minute suspension?
Suspended for 1 minute.
Ready to resume, Mr. President.
Session is resumed.
With the permission of the body, Mr. President, I move to consider proposed Senate Resolution number 628.
Hold on for 1 minute. I don't have that.
Mr. President, this is the resolution commending the 2014 recipients of the Soroptimist
All right.
Unsung Women Heroes Awards.
Consideration of Senate Resolution number 628 is in order.
Mr. President, may we ask the Secretary to read the title and the body and the text of the proposed Senate Resolution
The
628.
Secretary is directed to do so.
Resolution commending the 2014 recipients of the Soroptimist Unsung Women Heroes Awards for their tireless dedication and service in uplifting the welfare of disadvantaged women in their communities. Whereas Article 2, Section 14 of the 1997 Constitution states that the state recognizes the role of women in nation building and shall ensure the fundamental equality of women and men before the law. Whereas organized by Soroptimist International of the Philippines Region, A Foundation, Inc., and first awarded in 2009, the Unsung Women Heroes Awards aims to recognize women who take an active role in improving the lives of their fellow Filipinos through their work at the grassroots level. Whereas this year, 10 awardees were recognized by the Soroptimist International of the Philippines for their dynamic and proactive work in the field of education, financial literacy, good governance, and gender equality, among others. Whereas the 2014 Unsung Women Heroes Awards, namely LCM Cabral, Rosalia A. Cervantes, Sylvia L. De Leon, Olivia P. Lucas, Emily D.C. Lundang, Marillo P. Portasio, Adelina S. San Miguel, Fe L. Tolentino, Julieta B. Torres, Crispina S. Zafra, showed extraordinary effort and tireless commitment in improving the lives of women in their respective communities. Whereas for actively participating in community work and inspiring others to do the same, it is only proper that these awardees be recognized for making use of existing resources at their disposal in order to serve the marginalized members of our society. Now, therefore, be it resolved, as it is hereby resolved, to commend the 2014 recipients of the Soroptimist Unsung Women Heroes Awards for their tireless dedication and service in uplifting the welfare of women in their communities.
Majority Leader.
Mr. President, I move to adopt proposed Senate Resolution number 628, subject to style.
Any objection? Hearing none. Proposed Senate Resolution number 628 is hereby adopted subject to style.
Mr. President, I move to suspend the session to allow the senators to congratulate the awardees, and may we invite them for a photo opportunity with the Senate President and Senator Legarda, Mr. President.
Yes. The session is suspended 1 minute.
Ready to resume, Mr. President?
Session is resumed.
Mr. President, I move that we resume consideration of Senate Bill number 27, taking into consideration Senate Bill number 499 under Committee Report number 19. This is the picture-based health warning bill, Mr. President.
Any objection? Hearing none. Consideration of Senate Bill number 27 under Committee Report number 19 is in order.
Mr. President, the parliamentary status is that we are in the period of interpellation. Senator Pia Cayetano is the sponsor, and we ask that she be recognized. And the Minority Leader, Senator Juan Ponce Enrile, has the floor as the interpellator, Mr. President.
Senator Pia Cayetano, the principal sponsor of the measure, is recognized. And to avail of the period of interpellation, the Minority Leader, Senator Juan Ponce Enrile, is recognized.
Thank you, Mr. President.
Mr. President, a minute suspension.
1 minute suspension upon motion of Senator Cayetano.
Ready to resume, Mr. President.
Session is resumed.
May I continue with my interpellation, Mr. President?
Please proceed, Senator Enrile.
Madam Sponsor, I will start with Section 6. According to this section, in addition to the picture-based health warning, cigarette packages as well as other tobacco products or packages found in the market shall bear on one side panel additional information as issued by the DOH according to Section 15 of this Act, such as but not limited to additional health warnings, hotlines, or website for tobacco-related concerns. Now, and if we take into account Section 9, Section 9, cost of printing. All printing costs pertaining to packaging and labeling shall shouldered by tobacco manufacturers and/or importers. The user of the information is the government, but the cost is borne by the actually by the consumers of the country. Will this not be in the nature of an additional tax, Mr. President? A hidden tax that is being thrown on our producers and our manufacturers and our consumers.
No, Mr. President.
I will explain why I'm raising this point, Mr. President. If a company manufactures 1 million packs, that will translate to 100,000 cartoons. And if you divide that into 50 cartons per box, cardboard box, that will translate to about 2,000 cardboard boxes. And that will mean a lot of cost to the, that will mean at 1 centavo per printing cost, that will mean 10 million additional tax to the manufacturer, which will be passed on to the consumer.
Mr. President, these are printed warnings that we are requiring are a very small burden for the industry to bear. They are health warnings that is incumbent on any responsible corporation, and which the government should also ensure we all have a hand in, which the government should ensure reaches the public. So I don't believe anyone has, and this has been interpreted in any jurisdiction, these requirements for health labeling, as we discussed in the interpellation yesterday. All over the world, there are health warnings that are now required to be indicated in milk products, in over-the-counter products available in cafes and in grocery stores. So these are all warnings that have been considered to be reasonable, and those warnings actually are just one-color warnings. They are not even full color the way the graphic warning is. So we submit that this is a minor change that is being asked of the manufacturers as part of their social responsibility in conducting business in our country.
But I would have no problem, Mr. President, if it's limited to health warnings. But the wording of the provision is information not limited to health warnings. Because the Department of Health, for its own interest, can require the printing on one panel anything that it thinks would be good for the public to know. The way it's worded, it's a tricky wording of, I'm used to drafting contracts and legislation, and this is a very dangerous way of putting it.
Mr. President.
Not limited, excuse me, Madam. Not limited. The information does not have to be limited to health warnings. It could mean hotlines, whatever those hotlines are, or websites for tobacco-related concerns. But the wording of not limited to health warnings, we open the doors to the Department of Health to ask the manufacturers to bear the cost of anything that it wants to disseminate to the public.
Mr. President, may I explain? If you look at the types of information that will be included. It says additional health warnings, hotlines or websites for tobacco-related concerns, or tips on how to stop smoking. They are all related to the smoking and its consequences with respect to one's health. You could say that this enumeration is justem generis. So we, in the crafting of this law, we were of the opinion that the enumeration was clear enough that, as I said, it is justem generis. No, the not limited to the other types of information would fall within those types that were already listed. But by all means, if His Honor would like to improve on the wording, we are very open. But just to indicate and put on record what the objective of the committee was, I am putting it on record now that following the types of information indicated here, we are limited to this subject matter.
Would the distinguished sponsor, Mr. President, at the proper time accept an amendment to delete the phrase, but not limited to?
Yes, we are, like I said, we are very open to any amendments
so
that would improve.
The wording will be such as additional health warnings, hotlines, or website for tobacco-related concerns.
We have no problem with that, Mr. President.
All right. So at the appropriate time, that amendment will be introduced by the minority leader, which
If I'm still free, Mr. President.
we are certain about that, Mr. Minority Leader.
Thank you. I'm also certain, but who knows? Now, descriptors, Section 7. Am I correct in my interpretation that if a manufacturer can prove that a descriptor is true to fact,
Sorry, I didn't hear that. If
if
the
a manufacturer can prove that a descriptor placed on a cigarette pack is true to fact, that will be acceptable, because the wording is 90 days after the effectivity of this act, no cigarette packs or tobacco product packages shall contain any term, descriptor, trademarks, figurative, or any other sign, including colors, images, or numbers, or any other package or product, design, or feature that directly or indirectly create or are likely to create the false impression that a particular tobacco product is less harmful than any other tobacco product or brand. Suppose it placed there, non-filtered or filtered. Will that be prohibited?
so, the question now is if filter or unfiltered will be prohibited. That's the one I will respond to
Yes,
first.
if it does not, if there is a descriptor, but and it is true to fact, it can be proven that by the manufacturer empirically that this is true to fact. It's Turkish tobacco, Malagasy tobacco, Virginia tobacco, or whatnot. Will that pass?
Well, I'll be happy to try to respond to each example given by His Honor. Let me start with the general question first, which was if a manufacturer can prove that the claim or the use of a descriptor is actually true,
Yes.
will that be allowed?
Yes.
Let me respond by clarifying what the or stating on record what the objective of the law is. The objective of the law is not to allow any kind of descriptor, whether they are words, images, phrases, colors, that will give the impression that a product is less harmful. Because of the reason that there is no safe amount of nicotine. So if the company or the brand uses descriptors that include words such as light or mild, then that gives the impression to the consumer or potential consumer, the youth out there, that this is a less harmful product. This is okay. And that is what the bill hopes to address, that there would be no misconception that such a product is actually acceptable, that such product would not be harmful. So in that case, it would not be allowed. Now, if they are to use that descriptor because it describes another feature, so for example, they would say that the word light or mild refers to something else, perhaps taste. Well, they are free to say that, but the truth remains that to many consumers, and it has been concluded in the by the Framework Convention, that this would also give other consumers the belief that what is being referred to is the active ingredient, which is nicotine, then it cannot be allowed. And that is why we are including those types of descriptors as prohibited. We acknowledge that there may be other meanings for the word, but to the extent that it may give the public, and this is where we have to err on the side of protecting the health of the public, we cannot allow it. They obviously have the right to air their side, but without knowing any specific details, my response will be, I will err on the side of protecting the public and say that may give the public the impression that the harmful ingredients such as nicotine and many others, by the way, is not made any less, the product is not lighter, because there is no safe amount.
The classic example, for instance, is filtered or non-filtered. It's a fact. You can see it. There's no filter. It just indicates there what kind of cigarette there is inside the pack.
I think the specific question, Madam Sponsor, is if the word filter or non-filter is indicated in the package, would that be considered as falling within the prohibition under Section 7?
Yes, Mr. President. Thank you for the clarification. I'm clearing it with some of our technical persons. Mr. President, thank you for giving me time to just clarify that. The fact of a product being filtered or unfiltered, well, a product being filtered or unfiltered is a fact, no? It is something that can be proven. And yes, it is something that, if true, can easily be verified. But what I'm being told is that the use of the word filtered also gives the impression to the general public that therefore it is safer, therefore it is healthier, and therefore the FCTC has also recommended that the word filtered, although factual, I am not arguing with that, may be deceptive to the public, may give the public the impression that this is a better product, that this is a safe product, when the reality is there is no such thing as a safe cigarette. So that is the position that the FCTC has taken, and for now that is how we are interpreting it in the bill.
So if it is, if the reverse is printed, not filtered, will that be prohibited also?
Well, the objective of the law is to promote health. So we can admit that there is obviously a bias in terms of prohibiting descriptors that may be deceptive in terms of giving the impression of it being healthy. Would it be the same rule if you reverse it? If a product is on its face stated that, make no mistake, this is unfiltered, therefore not healthy, I guess we will accept that, because the bias should always be in favor of health, and that admittedly is a bias. But I do believe that that is a reasonable differentiation that the government should make, because there really should be efforts made to err on the side of health and not the other way around.
If you say, for instance, well, thank you for that, Madam Sponsor. If the pack says pure tobacco, of course, I'm sure that will be acceptable.
Pure tobacco?
Yeah.
I would think, Mr. President, I would think there is. I mean, from my untechnical background, offhand, seems okay.
Yes, but if they say 70% blended,
I wouldn't know. I wouldn't know what the concern there would be when we make reference to blended in terms of the health aspect. I wouldn't know.
They're selling it, pipe tobacco blend 76, I think it is. I used to smoke that.
I'm assuming it just has to do with flavor. We are not trying to make any. We are not trying to interfere with the descriptors as far as flavor is concerned. But as far as there may be a double meaning, then that is where the law seeks to make prohibitions or to prohibit the use of words that may have double meaning.
If you say non-menthol or mentholated,
the descriptor of menthol, if it's purely to indicate that there is a menthol flavor, should be allowed. But if this would be combined with light, such that the perception is that it is menthol flavor and also light, then that's where there may be a violation of the non-use of descriptors that would confuse the public. So what we have explained in the hearings when we would have these discussions with the manufacturers is that it is, as far as I am concerned, as the sponsor of the measure, if this should be looked in its totality. If there are clear indications that through the marketing campaigns, through the packaging, the use of the descriptors, the specific words, there is always this association with the product being healthier or lighter in terms of less harmful substances, then that would obviously be clear to us that the public is trying to be misled that this is a healthier product. But if it's just an isolated use of a word that is not as obvious as light or mild, then there may be basis for the descriptor to be allowed because it refers more to the flavor or something else. In other words, Mr. President, if I may, it is not the intention of myself, a sponsor in the committee, to interfere with any marketing campaign they have or any visual cues that they have developed over the years to establish their brand. But if there is a visual marking or descriptor that over the years have given the people, the public, the impression that it is safer, then I have to say that yes, it is the intention of the committee to break that association and to disallow the use of that descriptor.
The reason why I'm laying this into the record, Mr. President, because later on I will deal with this extensively when we come to the powers of the agency designated to implement this, the Department of Health, especially Section 15 or all the the succeeding sections. That's why I'm taking pains in asking this question. No, if you say in the label no additives, is that possible? No additives. You put in the label of a cigarette, no additives. There were cigarettes before which uses that.
I deferred to one of our resource persons before I replied, but I actually had a reply in mind, and we have the same response. Interestingly, I won't name the name of the magazine, but I subscribe to what I believe is a magazine that is very holistic in its approach, no? And I was so surprised one time that I actually found that they had cigarette ads in that magazine. It's a foreign magazine. And the difference, though, is that this cigarette brand is organic. So it was very clear to me, and at that time I was already very actively supporting and drafting this legislation. It's very clear to me that the objective was to put in the minds of the readers that an organic cigarette is healthier. But what do you mean by organic versus harmful tobacco products? No, organic simply means is that there are certain harmful types of pesticides that are not used in the fields where the plant is grown. But it doesn't mean that the harmful effects found in a tobacco product are not there. But how many people bother going through this thinking? No, not many, because time and again my friends ask me how to look at the nutritional statements on every package, and many people don't know. So, in response to His Honor's question, I use that as an example by way of analogy, because the use of the term no additive has that similar effect as organic. It's very general. What exactly does it mean? It just gives us the general impression that, oh, there's nothing harmful in there. What exactly does no additive means? And so the position that I take is that that may be misleading until perhaps the FDA defines what do you mean by no additives. Because in my sponsorship speech, I mentioned all the harmful ingredients in tobacco. Now, is it inherent in tobacco? If it was, then of course there is no additive because it is inherent in every tobacco product. But if there are some other products that were added to enhance the flavor, then in that sense there was an additive. But unlike the one with no additive, they both contain harmful tobacco ingredients. So my response to His Honor is that may be deceptive in the sense that people don't really know what no additive means, and the general impression has been this is therefore a healthy product or a healthier product.
So anyway, in order to shorten my interpolation at this on this issue, I would just like to know the position of the sponsor. Do you accept my notion that the appreciation of the descriptor is very subjective? In fact, it is really subjective to the party making the interpretation.
Definitely, Mr. President. As I mentioned since the last two interpellations, If you go into a grocery store, that's why there has been a lot of debate on the use of the terms less calories, light, healthier, low calorie, less fat. Because to me, when I say less fat, I already know that it could just be 5% less fat, which doesn't mean anything, because I bothered to read the nutrition labels. But to the general public, they're already so happy because their understanding of less calories, light, already means it's a healthier product, and it doesn't mean that. So yes, definitely, the interpretation of an expert, a health expert, the interpretation of a child, of a teenager, would all be would vary. There probably would be many different interpretations, but the fact remains that we always I shouldn't say the fact, but studies show we will always try to interpret something in the way that is acceptable to us. So if you'd like to believe that a product is healthier, we will interpret it as such. So if we see things that say light, less, and we all, who doesn't want to be healthy, majority of us will say, I'll take the one that says light, I'll take the one that says less, because that is the healthier choice. In the opposite, on the contrary, if you wanted to splurge, you'd say, mag-enjoy ako today, I'll get the full flavor, not the less, not the light.
If we say that the cigarette is 30% Turkish tobacco, 70% Virginia, or different variation, or it's composed of different types of tobacco, will that pass as a descriptor, an allowable descriptor?
It would seem, Mr. President, because those simply are descriptors as to the origins, and it does not relate to the health, the health component of the tobacco. So I would not have any issue with a descriptor based on the origins.
If we import cigarritos de Cuba, there are many people who smoke that here. Would that pass as a descriptor in cigars? Or Cuba Cortos?
Like I said, if it's with respect to origin, it's not part of the prohibition.
Yes. Thank you for that. Now, I go now to Section 8, minimum principal display surface. What would be the actual measurement of a 4950 square millimeters pack with the largest size? What is the length and what is the width?
49. What we are clarifying, Mr. President, right now is during the committee, which we will ensure is reflected in the committee report. So I will not be able to give the exact numbers, but what I will ensure is that in the committee report, can I just borrow? This is the small one. The other small one should be on the back. Apologize for that. I just wanted to be clear. I am using a flip-top box, which I understand is measured as 4840 square millimeters, with a height of 88 tall, and then length of 55, and then the width here in the side of 22.5. So the total is 4840. It is possible that when this was drafted, the measurement used was 4950. And in any case, it's not too far off. But what we are saying is, based on the bill at present, we want the display surface, if this is the front, the display surface, then 60% of this would contain the graphic warning. And same with the bigger, for the bigger products, it would be 60% of the bigger size. But if the packaging would happen to be smaller, then that is where we will impose a minimum, because we cannot have a situation where the packaging keeps getting smaller and the graphic warning is 60% of that smaller and that smaller packaging. In other words, to just be sure I am clear, the minimum should be 60% of this size of packaging, which as measured is 4840. So if we were to have a smaller packaging, it will not be 60% of a smaller packaging. It would have to be bigger, because the size, the visual surface that can be used to see the graphic warning will be compromised. It will be so small, so it will have to go up.
I think the current hard pack cigarettes in the country uses a measurement of 8855.
Yeah, so this is it, Mr. President.
Because the flip cover uses about 1 millimeter on the left and on the right in order to allow the closure of the flip top. So actually the width is 53. It's 55 because of that requirement of the flip top. Now, in the case of soft pack, it's 86, 53, 86 millimeter 53. So because if we are going to require 4950, we will have to ban the use of all of the current packaging, standard packaging of cigarettes in the country currently being used. And that will entail a lot of cost to the manufacturers.
Yes, what I made also very clear, Mr. President, during consultations and hearings with the manufacturers, is that it's not our intention to impose any change in their packaging. So, as I said, I'm working with this and whatever else is currently on the market. But if there would be anything substantially smaller, which I have also seen, no, it's about 2/3 the size of, then we would have bigger percentage because it is quite small already.
Now, coming to these specifications, the law simply says 60% of the two widest surfaces must be utilized. The requirement of utilization.
Are we discussing the size of the graphic warning, the 60% of the packaging?
Yes.
Yes. No, as I responded, Mr. President, it was not the intention of the committee to give that discretion to the implementing agency. What I said yesterday was that minimum of is there because we may encounter a manufacturer who would be happy to help promote health more and be the one to voluntarily make it 70 or 80%, not the agency. So we also mentioned yesterday that we are happy to improve the language if His Honor believes that it may cause confusion and erroneously give the implementing agency if it would erroneously make them think that they are given that discretion, because they are not. They are not.
Okay, thank you very much. But if once we come to the powers of the Department of Health, we will see that if we do not canalize this, the country might, or the manufacturers might have some difficulty. That's why I'm a little cautious in approaching this.
We are very happy to work with His Honor to define the powers of the implementing agency, so there is no confusion, and worse, that we would be blamed for crafting legislation that would result into an undue delegation of power.
Yes, so thank you. Section 12. It says, manufacturers, importers, and distributors of tobacco products shall be directly liable for any violation of the provisions of this Act in the case of a business entity or establishment, the chairperson of the board of directors, the owner, president, manager, and the corporate officials thereof shall be directly responsible therefore and shall be made accountable. And then it goes on. Agents and or representatives of the aforecited manufacturers, importers, and distributors who commit any violation of the provisions of this Act and its implementing rules shall be jointly and severally liable with the manufacturers. Is this joint and several liability limited to the civil liability or also the criminal liability?
Mr. President, I think I remember my criminal law well enough to know that we cannot have criminal liability joint, and we cannot have criminals joint and severally liable. So they each have to be tried on their own.
Yes, but some of the people who are
I mean, they may be charged, Mr.
Of course, these are not lawyers. We are going to, in fact, deputize ordinary local employees to help in the enforcement of this. We will authorize their deputization. So we better clarify this. That as far as civil liability, that it's joint and several.
Yes, I mean, if His Honor believes that it is better to indicate that, we are happy to. I did not, because I felt that that was, I mean, at the end of the day, as this will be implemented, those responsible for filing criminal cases would know that criminal liability can.
A person of the board of directors or the owner. For instance, in the case of British American Tobacco, for instance, that are not compliant with our law, and we file charges against them. How can we bring in the chairperson of the AT country? And the owners are probably millions of stockholders who are, because that's traded in the stock market.
Yes, Mr. President, the intention of the measure and the provision in particular, obviously, is to make those responsible to the extent that they can be held responsible. So in other words, obviously, when we term owner, that is in reference to a single proprietorship, not to every single stockholder.
Okay.
That it is a single proprietorship, then the liability is also personal.
Single owner, meaning, or a few owners.
Yes.
It's a
They are registered as a single
corporation.
Well, single proprietorship under Philippine law, we refer to a single proprietor who is not registered as a corporation but does business in his own name. But there is no separate identity. He just has a business. In that sense, he doesn't have a separate identity, unlike a stockholder or a stockholder, or for that matter, a member of the board.
single proprietor is the owner of a sari-sari store or an unincorporated
Business.
unincorporated business.
Yes, Mr. President.
Because if there are two or more of them, it becomes a partnership.
Yes, Mr. President.
So we have to clarify this because we are the wording of the law. The wording of the law is such that it could be misinterpreted, and it says manufacturer will not have any board. The owner, resident, manager, and the corporate official thereof shall be directly responsible therefore. I think I suggest that we recraft this later on.
That will clarify this. The sole intention of the committee was to ensure that whether it is any amendments that would clarify any confusions he sees that could possibly come up in the interpretation of the provision.
Now, Section 14, penalties for non-compliance. Subparagraph 1. On the first offense, a fine of not more than 1 million pesos. So a judge can impose 1,000 pesos.
Yes, Mr. President.
Yeah. Especially for the itinerant vendors who are peddling cigarettes with containers slung over their neck in the heavy traffic of the metropolis.
Well, actually, Mr. President, those kind of vendors are covered by Section 13.
Not Section 14.
13 and 14B. Because we distinguish between, exactly as his honor says, these itinerant vendors, sari-sari store owners, retailers. We of course take notice of the reality that they operate smaller businesses. Therefore, the penalties imposed in 14B are much less.
Now, second subparagraph. The second offense, a fine of 5 billion pesos shall be imposed. How did you come to that jump?
The assumption, Mr. President, subparagraph number 3 is not yet imposed, but by the second offense, it's higher, and the third is higher.
Then on the third offense, a fine of not more than 20 million.
Exactly the same reasoning, Mr. President.
Yeah. But and the third offense is 4 times the second offense. Is that an intentional progression?
The intention is to make a gradual, a progression, in fact, that would be meaningful, because we know that 1 million is really nothing for the companies involved in the manufacture, importation, and distribution.
So if the offense is in the case of the first offense, what court will take jurisdiction over this? Municipal court, regional trial court?
Well, the jurisdictions of the courts are defined by law already, Mr. President, and I believe this would all fall under the RTC.
RTC, or RTC.
RTC, Mr. President.
Yes. I refer to line 24 all the way to line 30. Each batch of non-compliant tobacco packages, regardless of size, that are withdrawn from the manufacturing facility, imported into the Philippines for sale to the market, transferred to other facilities, or delivered to the retail establishment after the compliance date shall constitute one offense. Suppose a batch. What is, in the first place, what do we mean by a batch? A batch in the language of cigarette manufacturing.
From what I know, Mr. President, there really are batch numbers here. So this would be that the reason why we described it as such is so that there is no mistake that this is a particular volume of products that were that are withdrawn from a manufacturing facility and imported and transferred. So they are all one batch. They are a particular number of products that were all shipped and delivered, and then from there disbursed to various retailers. So in other words, it is easier to identify that they came from that one particular source in place and in time. They were, whether they were, despite the fact that they ended up in different places, they all came from that particular source in that particular time.
If X corporation manufactures 1 million packs of cigarettes, and uses 2,000 boxes to contain them for distribution, and then 500 boxes are taken out in the morning, 500 boxes will be taken out at noon, and another 500 boxes will be taken out in the evening, and the last batch will be taken out midnight. That will constitute 4 offenses immediately. Am I correct?
Well, actually, Mr. President, I believe we are quite reasonable here because we already assume that that is just one batch.
No, but the wording is each batch withdrawn. It is the withdrawal that establishes the batch.
Correct. So as that is withdrawn, that is one batch.
And how about the numbered batch that the lady sponsor mentioned, according to manufacturing practices?
Let's clarify what if that batch that was produced, 50% was left in the warehouse and 50% was released, then that 50% is that one batch, because from the time of withdrawal, because there would be time to fix that problem. If they continue to release that other batch that is left behind, then that would constitute 2 batches.
So if they use 2 trucks to remove 500 boxes of cigarettes, one after the other, will that constitute 1 offense or 2 offenses?
Well, I would distinguish, Mr. President, if it was imported or exported. If it was imported, then that whole batch is one batch. If it is locally manufactured, assembled, etc., and they are withdrawn on separate days, on separate, they're totally separate acts involved, then they could be broken up. Again, we can clarify this further if His Honor believes that this is still confusing.
Maybe why don't we just simplify this by saying it's withdrawal?
Every withdrawal.
Its withdrawal from the from the
Manufacturing facility.
manufacturing facility.
Yeah.
We can, Mr. President. As I said, I'm more than happy to accommodate any clarifications.
So the proposed amendment is, instead of each batch, we will simply say every withdrawal
Yeah. Each withdrawal.
or each withdrawal.
If they're not compliant, you're taking out to the market already.
Yes. Yeah.
Yes, I'm making note of it, and in the proper time, we can incorporate the same. Thank you.
Who will determine if how do we I'm not that familiar anymore with the practices in the industry. Do we have storekeepers, internal revenue storekeepers in every cigarette manufacturing establishment?
I'm sure there is a warehouse
We used to have.
in the warehouses in the.
Yes. In the.
I presume, Mr. President, because that is where all the products are kept, so there would be somebody in charge of the releases.
We call them storekeepers. Sometimes even customs officers are posted in warehouses of importers for distilled spirits and tobacco products. So maybe we should utilize them to determine the withdrawals, so in order to make the implementation of this law effective.
We can explore that, Mr.
Because
President.
it will be a problem of proof to determine whether if there was withdrawal of so much, or so to prevent the accumulation of penalties.
Yes, Mr. President. We will talk to the different manufacturers and also FDA and others involved in more familiar with this process, so we can see what kind of more details we can provide in the bill.
Yeah. Retailers and sellers, fine of 5,000, first offense. Second offense, fine of 10,000, double. And on the third offense, fine of not more than 20,000. And again, each day that non-compliant tobacco packages are found in the retail store of the retailer, after the compliance date shall constitute one offense. So every day there's an offense. Is that the intent of this law?
Yes, Mr. President.
May I stop at this point and continue on section 15?
Yes, Mr. President. Whatever is the preference. May I also just put on record one of the responses I have to the question His Honor posed yesterday on the data we have on text-based warning and graphic health warning. I will just summarize this and then give a copy to His Honor and also submit one for the record. This is a study conducted by Canada. In 1989, they included text warning in their cigarette packages, and they have a study on the prevalence rate of smoking among teenagers aged 15 to 19. so that was imposed in 1989. And the study on the prevalence rate, if you look at 91 to 99, from 23% it went up to 27%, then 28% in, well, sorry, let me repeat that for clarity. In 1991, it was 23%, 1994, 27%, 1994 to 1995, 28%, 1996 to 1997, 29%, 98 to 99, 28%, and 99, 28%. So more or less, Mr. President, so there is a gradual decline over the years, from over 12 years, from 2000 to 2012, 25%, 22, 22, 18. In 2006, it went down to 15%. In 2009, 13%. In 2010 and 2011, 12%. And in 2012, 11%. If there are other studies, I will also put it on record.
Thank you. Thank you, Mr. President.
Thank you, Senator
Mr.
Enrile.
President.
Next session.
No
And-
objection, Mr. President. Sir President, let me second the motion to suspend consideration of Senate Bill number 27, take in consideration Senate Bill number 499 under Committee Report number 19.
Consideration of the measure is suspended.
Sir President, I move to adjourn the session until 3 o'clock 2014.
Session is adjourned until 3 p.m. of Monday, May 19, 2014.